can hear me?
I can, and does the same go for me?
Yes, it does. Thank you, sir.
Thank you.
I was turning to the CCRC and criminal appeals. The CCRC is a statutory body with the power to refer criminal cases to the Court of Appeal Criminal Division, where it considers that there is a real possibility that a conviction may be overturned. In March 2021, the Court of Appeal considered 42 convictions that had been so referred following the judgments by Mr. Justice Fraser. As you know, there were two grounds of abuse of process that were pursued before the Court of Appeal as grounds of appeal. First, that the defendants could not have a fair trial, and secondly, that his or her trial was an affront to the conscience of the court. The Court of Appeal, having considered the judgments of Mr. Justice Fraser and the individual circumstances of the cases before the court, held that the failures in investigation and disclosure were such as to mean that a fair trial was not possible in any of the cases where Horizon data had been essential to the prosecution. That constituted all but three of the appeals before it. Moreover, the court found that, quote, the failures of investigation and disclosure were so egregious as to make the prosecution of any of those cases an affront to the conscience of the court. And so in all but three cases, the appellant's convictions were quashed. Further appeals have subsequently taken place in respect of more sub-postmasters and others who were convicted, and further convictions have been quashed and continue to be quashed. With that criminal and civil litigation in mind, the key milestones in advice and investigations that I will address over the remainder of today, although no doubt there will be others in due course, are as follows. Firstly, the Helen Rose report, a 2013 report by the Post Office's security fraud analyst, which touched on Horizon integrity issues. Secondly, the Second Sight interim report, a 2013 report by forensic accountants, which on an initial review did not identify systemic issues with Horizon, but which identified bugs and was critical of the Post Office's handling of its investigation. Thirdly, the Clark advices, namely advice from Simon Clark, a barrister at the Post Office's solicitors, Cartwright King, again in 2013. A first significant advice addressed to the reliance on Gareth Jenkins as an expert witness in Post Office prosecutions will be considered, and a second advice concerning the need to record and retain information. Fourth, the Second Sight report itself, which was finally completed on the 9th of April 2015, and which, amongst other things, was critical of the access that was provided by the Post Office to documents that were considered necessary for the purposes of that investigation. Fifth, various advices from Brian Altman King's Counsel in the period 2013 to 2015, which addressed the review being carried out by Cartwright King, which addressed advice in relation to mediation, advice on the Post Office's prosecution role, and advice on the charging of theft and false accounting. Six, advice from Jonathan Swift, now Sir Jonathan Swift, and Christopher Knight in 2016 that formed a review on behalf of the then chairman of Post Office, Tim Parker, concerning the steps taken in response to complaints by sub-postmasters. Seventh, various advice given by Mr. Altman in the period from 2016 onwards, which followed the Swift review, addressing Post Office's criminal prosecutions and advice on the judgments of Mr. Justice Fraser and their implications for the safety of convictions. And then eighth, advice from various legal professionals in respect of the group litigation. Of course, the story of wide-scale and executive-level knowledge can be traced further back than these reports. In 2009, in Rebecca Thompson's Computer Weekly article, she referred to problems with Horizon. In the same year, 2 members of Parliament reported their constituents' concerns about Horizon to the Minister of Postal Affairs, who in turn forwarded their letters to the Managing Director of the Post Office. You, sir, will wish to investigate those early reports and examine the response to them. As I've already discussed, in relation to Phase 3, this will include the August 2010 report by Mr. Ismay, entitled Horizon, Response to the Challenges Regarding Systems Integrity. The inquiry will investigate why little appears to have been done in the intervening period before the reports, the 8 reports and advices, which I now turn to address. So first, the Helen Rose report. On the 12th of June 2013, Helen Rose wrote a report in respect of Horizon issues at the Lepton branch. We needn't turn it up, but that's poll 000030214. Helen Rose was a post office security fraud analyst who was looking into a transaction correction at the branch because the postmaster had denied reversing a transaction for £76.09 and who had involved a forensic accountant as he believed his reputation was in doubt. The report included the contents of a series of emails between Miss Rose and Gareth Jenkins, who I've already mentioned and will come to again shortly, because in addition to having significant input into the Horizon system as an employee of Fujitsu, he was also an expert witness used in the Post Office's prosecutions of sub-postmasters. During the course of her investigation, on the 30th of January 2013, Gareth Jenkins had stated in an email to Miss Rose that, quote, it isn't clear what failed in respect of the Lepton branch. And an email from Miss Rose on the 13th of February 2013 included the following important sentence: I know you are aware of all the Horizon integrity issues. Whilst Miss Rose concluded that the system in that case had behaved as it should, she expressed concerns that, quote, we cannot clearly see what has happened on the data available to us, and this in itself may be misinterpreted when giving evidence and using the same data for prosecutions. The recommendation was to change the logs so that, quote, that system created reversals are clearly identifiable. As I will come to explain, the content of those underlying emails and Miss Rose's report was later seen to be significant by Simon Clark, the barrister at Cartwright King Solicitors, who was concerned about the conduct of the Post Office's prosecutions. Second, then, the interim report of Second Sight. In May 2012, following the intervention by James Arbuthnot MP, now Lord Arbuthnot, the Post Office agreed to engage a firm of forensic accountants to review Horizon. Following discussions involving the Post Office's senior management, Lord Arbuthnot and Alan Bates and Kay Linnell of JFSA, Second Sight Support Services Limited, which I'm going to call Second Sight, were appointed to carry out the review. The investigators were Ian Henderson and Ron Warmington. It's worth noting at this stage, for reasons that will become clear in due course, that a paper was issued by the agreement of the Post Office and the JFSA called Raising Concerns with Horizons, which sought to reassure sub-postmasters. That's poll 50218. It was signed by the Post Office on the 17th of December, and at page 5 included the following paragraph. In order to carry out the inquiry, Second Sight will be entitled to request information related to a concern from Post Office Limited, and if Post Office Limited holds that information, Post Office Limited will provide it to Second Sight. The remit of the investigation was defined in Second Sight's interim report, which is poll 000029650, as follows. Quote, to consider and to advise on whether there are any systemic issues and or concerns with the Horizon system, including training and support processes, giving evidence, and reasons for the conclusions reached. it was agreed that Second Sight's report would, quote, report on the remit and, if necessary, will contain recommendations and or alternative recommendations to Post Office Limited relating to the issues and concerns investigated during the inquiry. The report and recommendations are to be the expert and reasoned opinion of Second Sight in the light of the evidence seen during the inquiry. Second Sight had been asked to investigate 47 individual cases that had been submitted to either the JFSA or to the Office of Lord Arbuthnot, and which had been highly critical of the Horizon system, and in many cases the way that the Post Office had dealt with the matters reported. After notifying the wider Post Office network about the proposed investigation, an additional 14 cases were accepted for investigation. At the outset of Second Sight's report, which was produced in July 2013, it was observed that, quote, whilst in no way minimising the potential importance of the cases under review, this level of response suggests that the vast majority of sub-postmasters and branches are at least reasonably happy with the Horizon system. That observation was repeated by the Post Office and others in the years that follows, and the inquiry will investigate why so few individual sub-postmasters came forwards at that time. Second Sight conducted what were called spot reviews. That is because the investigators considered that it would not be efficient or cost-effective to examine all of the issues raised by sub-postmasters or covered in the Post Office case files. Instead, the investigators would conduct a, quote, fast-track review of the information available in order to identify the key issues that were relevant to the remit of the investigation. Each issue was then dealt with as a spot review. A case with multiple issues would give rise to multiple spot reviews, each of which would be dealt with on an individual basis. The reports issued by Second Sight were issued in a way that maintained the anonymity of each individual sub-postmaster. Second Sight noted early on in the interim report that the Post Office's responses to the spot reviews were long and highly technical documents, which in some cases presented counter-assertions based on the standard operating procedures and controls, rather than, quote, tangible evidence, end quote, of what had actually happened. The interim report addressed 4 spot reviews in respect of whether defects in Horizon caused some of the losses for which sub-postmasters and their staff were blamed. Second Sight said there was still much work to be done to investigate, but they were able to conclude that in one of the 4 cases, quote, although the Horizon system operated as designed, the lack of timely, accurate and complete information presented to the sub-postmaster was a significant factor in his failing to follow the correct procedure. That's poll 3029650 at page 5. In another, the Post Office made changes to the relevant standard operating procedures just a few days after the sub-postmaster had been suspended, and Second Sight noted that it's possible that if that change in procedures had been implemented earlier, many of the problems would not have occurred. During the course of their investigation, the Post Office had disclosed to Second Sight the existence of defects in Horizon that had impacted some 76 branches. This included, firstly, the receipts and payments mismatch problem that was said by the Post Office to have impacted 62 branches. Secondly, the local suspense account problem, which was said by the Post Office to have affected 14 branches. And thirdly, one other single bug in the Horizon software. The report from Second Sight detailed a wide range of frequently reported issues, and their conclusion in this regard was pointed, stating, and this is the same reference, page 7 at paragraph 7.3, we can't help concluding that had Poll investigated more of the, quote, mysterious shortages, end quote, and problems reported to it with the thoroughness that it has investigated those reported to it by Second Sight, Poll would have been in a much better position to resolve the matters raised and would also have benefited from process improvements." End of quote. The authors noted that the investigation division in the Post Office was not contractually required to inquire into matters where crime was not suspected. They noted other issues, such as complaints by sub-postmasters that they were only provided with a full copy of their contract with the Post Office when the Post Office commenced litigation against them or recovery action against them. The interim report's conclusions were preliminary only, acknowledging that there was still much work to be done. Nevertheless, the conclusions were as follows, same reference, page 8. First, Second Sight had so far found no evidence of systemic problems with the Horizon software. Second, they were aware of 2 incidents where defects or bugs in the Horizon software gave rise to 76 branches being affected by incorrect balances or transactions, which took some time to identify and to correct. Third, occasionally an unusual combination of events, such as a power or communications failure during the processing of a transaction, could give rise to a situation where a timely, accurate, and complete information about the status of a transaction was not immediately available to a sub-postmaster. Fourth, when individual sub-postmasters experienced or reported problems, the Post Office's response could appear unhelpful, unsympathetic, or simply fail to solve the underlying problem. The lack of a user forum or similar facility meant that sub-postmasters had little opportunity to raise issues of concern at an appropriate level with the Post Office. Fifth, the lack of an effective outreach investigations function with the Post Office resulted in the Post Office failing to identify the root cause of problems and missing opportunities for process improvements. Sixth, the end of the trading period processes could be problematic for individual sub-postmasters, particularly if they were dealing with unresolved transaction corrections. The lack of a suspense account option meant it was difficult for disputed transaction corrections to be dealt with in a neutral manner. On the day that the interim report was published, the Post Office announced the creation of a mediation scheme. Its press notice, having quoted from the then Chief Executive Paula Venables, announced as follows. This is CWU 702. The creation of a working party to collaboratively review the complete review of cases started by Second Sight last year. This would examine the themes identified by Second Sight and consider all cases brought forward by the JSA and MPs, together with any new themes which emerge from these cases. On the 26th of August 2013, the Post Office made a further announcement and created the Initial Complaint Review and Mediation Scheme, the objective of which was to, quote, address the concerns raised by some sub-postmasters regarding cases which they feel require further resolution. A working group comprising the Post Office, JFSA, and Second Sight was established to develop and monitor the scheme, and Sir Anthony Hooper, a former Court of Appeal judge, was appointed as the independent chair. The scheme received 50 applications before the deadline for such applications, 150 applications before the deadline for applications expired on the 18th of November 2013. There are a number of aspects of the interim report that will become important parts of your investigation. One of these is the interim finding by Second Sight that they had so far found no evidence of systemic problems with the Horizon software. The inquiry will examine to what extent that finding was used or misused by the Post Office and others to support or justify their actions against sub-postmasters and then in litigation. Can I turn to the clerk advices? By July 2013, the Helen Rose report and the Second Sight interim reports had been completed, and it became clear that there were issues with the disclosure that had been given in criminal prosecutions. Simon Clark, a barrister at Cartwright King Solicitors, became concerned about the conduct of the prosecutions. On the 8th of July 2013, Mr. Clark advised on the need to conduct a review of all post office prosecutions so as to identify those who ought to have had the certain material concerning problems with Horizon disclosed to them, as well as a review of current cases where there had been no disclosure when there ought to have been. He indicated that the existence of bugs needed to be disclosed to defendants where the test for disclosure was met, and he set out the scope of the exercise to be conducted. That exercise has been referred to as the CK, referring to Cartwright King, the CK SIFT review, and that reviewed all cases conducted since the 1st of January 2010. The inquiry will in due course ask to what extent this exercise was truly independent and whether it was sufficient in its oversight. On the 15th of July 2013, Mr. Clark wrote an advice on the continuing use of Gareth Jenkins as a prosecution witness. The advice was entitled, quote, "Advice on the use of expert evidence relating to the integrity of the Fujitsu Services Limited Horizon system." I wonder whether we could turn that up. Poll 406798. Thank you. I'll introduce it in summary first. Mr. Clark explained in the advice that the Royal Mail Group and Post Office had relied on Mr. Jenkins, or Dr. Jenkins, or Dr. Jennings, as he's referred to by Mr. Clark, for many years, and had provided many expert statements in support of prosecutions, that it had negotiated with and arrived at joint conclusions and joint reports with defence experts, and that he had attended court to give evidence on oath at criminal trials. 5 recent examples were selected by Mr. Clark. Mr. Clark identified that the Helen Rose report and the Second Sight interim report had both raised concerns concerning bugs. He then referred to a conversation on the 27th of June between the Post Office and Cartwright King, which identified that some within the Post Office had been aware of bugs affecting up to 30 offices. On the 28th of June 2013, Mr. Jenkins confirmed that he had told Second Sight about 2 bugs during the course of their investigations. That's the receipts and payments mismatch and the local suspense account bugs. Mr. Clark highlighted that expert statements had been provided by Gareth Jenkins in criminal proceedings, all attesting to the robustness and integrity of Horizon, and expressed in terms and were phrased in such a way that would drive the reader to the conclusion that there must not be any bugs. Can we turn to page 13 of the advice, please? At paragraph 37 in his conclusions, Mr. Clark asked, "What does all this mean?" And he answered his question. Quote, "In short, it means that Dr. Jennings," that's Mr. Jenkins, "had not complied with his duties to the court, the prosecution, or the defence. It is pertinent to recall the test under which a prosecution expert labours," that's his word. Quote, within a quote, "An expert witness possessed of material which casts doubt upon his opinion is under a duty to disclose the fact to the solicitor instructing him, who in turn has a duty to disclose that material to the defence. The duty extends to anything which might arguably assist the defence. Moreover, it is a positive duty." And his footnoted reference is to a decision of the Court of Appeal in Ward. In paragraph 38, Mr. Clark advised as follows: "The reasons as to why Dr. Jennings failed to comply with this duty are beyond the scope of this review. The effects of that failure must, however, be considered. I advise the following to be the position. 1. Dr. Jenkins failed to disclose material known to him, but which undermines his expert opinion. This failure is in plain breach of his duty as an expert witness. 2. Accordingly, Dr. Jenkins' credibility as an expert witness is fatally undermined. He should not be asked to provide expert evidence in any current or future prosecution. 3rd, similarly, in those current and ongoing cases where Dr. Jenkins has provided an expert witness statement, he should not be called upon to give that evidence. Rather, we should seek a different, independent expert to fulfill that role. 4th, notwithstanding that the failure is that of Dr. Jennings, and arguably of Fujitsu Services Limited being his employer, this failure has a profound effect on Post Office Limited and Post Office Limited prosecutions, not least because by reason of Dr. Jenkins' failure, material which should have been disclosed to defendants was not disclosed, thereby placing Post Office Limited in breach of their duty as a prosecutor. Next, by reason of that failure to disclose, there are a number of now convicted defendants to whom the existence of bugs should have been disclosed but was not. Those defendants remain entitled to have disclosure of that material, notwithstanding their now convicted status. He then turns in brackets to the review. Next, further, there are also a number of current cases where there has been no disclosure where there ought to have been. Here we must disclose the existence of the bugs to those defendants where the test for disclosure is met. Lastly, in an appropriate case, the Court of Appeal will consider whether or not any conviction is unsafe. In doing so, they may well inquire into the reasons for Dr. Jenkins' failure to refer to the existence of bugs in his expert witness statement and evidence. End of quote. That advice was given to the Post Office in July 2013, 8 years before the Hamilton appeals. It was not disclosed until November 2020. The inquiry will seek to establish why the issues raised in the advice and the advice itself, which was so important to the Court of Appeal's subsequent findings, were not disclosed earlier by the Post Office. Meetings have been taking place between the Post Office and Cartwright King in July of that year, 2013, to consider issues relating to Horizon and the prosecution of offences. Mr. Clark had advised that there ought to be a single central hub to act as the primary repository for all Horizon-related issues. Participants were apparently informed that they should bring all Horizon-related issues that they had encountered into that meeting. Minutes were to be taken at the meeting. They were to be centrally retained and disseminated to those who required the information. At some point between the conclusion of a conference call on the 31st of July 2013 and a subsequent advice that he wrote, it became unclear to Mr. Clark as to whether and to what extent material was either being retained or centrally disseminated in accordance with those instructions. Information was relayed to Mr. Clark, and we can see that in his subsequent advice. Can we look at poll 406799? This is a separate advice called the duty to record and retain material, sometimes referred to as the shredding advice. Can we turn over the page, please, and look at paragraph 5. He refers to the conference call to which I've referred and says, At some point following the conclusion of the third conference call, which I understand to have taken place on the morning of Wednesday, the 31st of July, it became unclear as to whether and to what extent material was either being retained centrally or disseminated. The following information has been relayed to me. 1. The minutes of a previous conference call had been typed and emailed to a number of persons. An instruction was then given that those emails and minutes should be, and have been destroyed, the word shredded was conveyed to me. Second, handwritten minutes were not to be typed and should be forwarded to Pol's head of security. Third, advice had been given to Pol, which I report as relayed to me verbatim, then in italics, quote, if it's not minuted, it's not in the public domain and therefore not disclosable, end of first quote. Beginning of second quote, also in italics, if it's produced, it's available for disclosure. If not minuted, then technically it's not. Point 4, some at Pol do not wish to minute the weekly conference calls. That information was clearly of concern to Mr. Clark, and so he wrote the shredding advice. That advice contained trenchant criticisms. He made it clear that there was a duty to record and to retain material that could not be abrogated. He explained that to do so would mount to a breach of the law, and in the case of solicitors and counsel, serious breaches of their respective codes of conduct. Mr. Clark advised that where such a decision was taken, partly or wholly, in order to avoid future disclosure obligations, it may well amount to the crime of conspiracy to pervert the course of justice. Further, that if contrary advice was given, his own advice would itself become disclosable. Mr. Clark set out in strong terms that the only proper way forwards was for the conference calls to be minuted properly, these minutes to be centrally retained and made available to all those who properly required access to them. Further, he emphasised that individual investigators with knowledge were bound by both the duty to record and to retain information and to inform the prosecutor, the post office, about it. He emphasised the need for a mechanism to permit the collation of all Horizon-related bugs, defects, complaints, queries, and Fujitsu remedies arising from all sources into one location. His conclusion was that any advice to the effect that if material is not minuted or otherwise written down, it doesn't fall to be disclosed, was wrong and represented a failing fully to appreciate the duties of fairness and integrity placed upon a prosecutor's shoulders. The inquiry will seek to establish what it was that the Post Office had destroyed and look into whether there was a culture of not recording information, of document destruction, and of withholding important information from disclosure. It will also, of course, look into who was aware of Mr. Clark's advice, or the effect of it, or any of its contents, and what they did with that knowledge, and what subsequent action was taken on the basis of it. That can come down from the screen. Can I turn to the Detica report? Meanwhile, Detica, a subsidiary of BAE Systems, had been carrying out an investigation and on the 1st of October 2013 published a report called Fraud and Non-Conformance in the Post Office, Challenges and Recommendations. That's Poll 30-29677. This followed a pilot which looked at the data that was available to security teams relating to branch activities and transactions and the quality of information and processes shared by the central teams. It also conducted a detailed data analysis of branch behaviour. The report had been commissioned by the Post Office's head of security, John Scott, and its Legal and Compliance Director, Susan Crichton. The Detica report was acknowledged to have taken place against the backdrop of wide-ranging changes within the Post Office, which included public discontent amongst sub-postmasters relating to the Horizon system and the review of Horizon by Second Sight. The report identified a number of shortcomings that were said to pose serious risks to the financial performance of the business. This included, amongst other things, findings that, quote, post office systems are not fit for purpose in a modern retail and financial environment, end quote, expressing a concern about the difficulty in recording information from multiple transaction systems. The cross-reference to that is Poll 000296677, page 37 at paragraph 7.2.2. It also criticised the investigations process, stating there, quote, needed to be a concept of quality, control and rigour in the investigation process. Same reference, page 41, paragraph 7.4.1.3. Pausing there, all of the events that I have so far addressed occurred in 2013. As part of phase 6 of the inquiry, we will be looking at what was going on at executive level and at board level in that period and in the period that followed to address the problems that were being raised and the extent to which there was a failure of governance. Can I turn to the Second Sight report? By the summer of 2014, on the 25th of July, Second Sight issued what was entitled Briefing Report Part 1. That dealt with, first, the general information about the Post Office, its branches, and the role of sub-postmasters, a description of the training and support functions, as well as the Post Office audit and investigation processes, an overview of the Horizon system and associated equipment, an introduction to the application of double entry accounting in Horizon, a description of significant branch operating and reporting procedures and the associated processing of transactions, an outline of the treatment of losses and surpluses, an analysis of typical errors. Second Sight then issued a first version of their Part 2 report on the 21st of August 2014, which recognised that a number of issues were still under investigation. The Post Office provided a response to it on the 22nd of September 2014. The inquiry will hear about some important events which occurred shortly before the final report was published. Before I address the substance of the final report, it's necessary to detail some of those events as they provide an important context. By December 2014, Radio 4 Today programme had a segment on Horizon. The programme first heard from Jo Hamilton, who explained what had happened to her and that she would love to see all of the sub-postmasters' names cleared and would love to see them have some of their money back. Next came Lord Arbuthnot, who spoke powerfully about the problems that the mediation scheme was facing. He said that the Post Office were, quote, trying to sabotage that very mediation scheme that they set up, and they're doing it in secret. A significant part of his complaint was that, in his view, Second Sight had shown their independence, and Post Office were trying to overcome their recommendations. He said that he had, quote, lost faith in Post Office's determination to see it through to a proper end. In response, Mark Davis, the communications director for the Post Office, emphasised what he said was a small number of people who said they'd had problems with Horizon, and, a phrase which I'll be coming back to, the review had, quote, found no evidence at all of any systemic problems with the Horizon system, end quote. In words that would attract some further notoriety, Mr. Davis said that he was sorry if people have, quote, faced lifestyle difficulties, lifestyle problems, as a result of their having been working in Post Office branches. As part of this inquiry, the strategies adopted by the Post Office in response to this emerging scandal and who was responsible for the formulation of those strategies and the development of them will be investigated. The Today programme interview was followed shortly thereafter by a meeting of the Business Innovation and Skills Select Committee on the 3rd of February 2015. In that committee, Ian Henderson of Second Sight told MPs that the Post Office was obstructing the work of Second Sight. This was denied by the then CEO of the Post Office, Paula Venables. It was also at this committee meeting that the General Secretary of the National Federation of Sub-Postmasters, George Thompson, said, amongst other things, that the NFSP, quote, represents 7,000 sub-postmasters. If there was a systemic problem, we would be absolutely inundated. And a little later, over the 15 years, the Horizon system has been fantastically robust. On the 10th of March 2015, it was announced that the working group was to be wound up. According to Second Sight, this was the day before they were due to circulate a draft of the report to all members of the working group, and the same day that Second Sight were notified that their contract was being terminated by the Post Office. Your inquiry will be looking at what factors led to the failure of the complaints and review mediation scheme. Returning to the Second Sight report, an updated version of the Part 2 report was finally completed on the 9th of April 2015. That's poll 000-29849. The Part 2 report was highly critical of the Post Office's conduct in respect of providing access to information. You'll recall that when I addressed the interim report, I highlighted that a document called, quote, Raising Concerns with Horizon had sought to reassure sub-postmasters, confirming that Second Sight would have access to all of the documents that it needed. However, the investigators explained at the outset, that's paragraph 2.1, that they had experienced significant difficulty in obtaining access to a number of documents that they considered to be necessary for the purposes of their investigation. They fell into three categories. First, the complete legal files relating to investigations and criminal prosecutions commenced by Post Office that related to the applicants. Second, the complete email records relating to a small number of Post Office employees working at the Bracknell office of Fujitsu in 2008. And third, detailed transactional records relating to the items held in Post Office's suspense accounts and to disputed transactions in a number of third-party client accounts held by Post Office. In respect of the legal files, Second Sight explained that they could not properly test the Post Office's assertion that there was, quote, no reason to conclude that any original prosecution was unsafe, end quotes. They were told that reviewing individual investigative and prosecution files didn't fall within their terms of reference. We now know, of course, that the assertion that there was no reason to conclude that any original prosecution was unsafe, something that Second Sight wanted to investigate further, was fundamentally wrong. In respect of access to the emails, Second Sight explained that the Post Office had stated that it wasn't possible for unauthorised remote access to transaction data to have occurred at the Fujitsu office in Bracknell, and that it needed further evidence properly to research this. Again, we now know that Post Office's assertion regarding remote access, again something that Second Sight wanted to investigate, was wrong. In respect of transaction data, Second Sight highlighted that the Post Office had client accounts with business partners such as the Royal Mail, the Bank of Ireland, HMRC, DWP, the DVA and others, where significant unreconciled balances existed centrally, which may represent transactions from individual branches that should have been credited back to individual branch accounts. They were unable to investigate this without the relevant information being provided to them by the Post Office. Can we turn up Second Sight's conclusions in respect of access to information? They're at poll 000-29849. And can we turn to page 49 of that document, please? Over the page, please. And go down to the bottom under conclusions at paragraph 26.1. Their conclusions, 26.1. When we started our work on these important matters in July 2012, we believe there was a shared commitment with Post Office to, quote, seek the truth, irrespective of the consequences. This was reflected in us being provided with unrestricted access to highly confidential and sensitive documents, including legal advice relating to individual cases. This position was recognised and well received by other stakeholders, including the Right Honourable James R. Bucknott MP and the JFSA. 26.2. However, as time progressed, and particularly in the last 18 months, it has been increasingly difficult to progress our investigations due to various legal challenges by Post Office. There have been considerable delays in receiving responses to requests for individual information, and legal issues have been raised, such as data protection and legal privilege, as being the reason various documents could no longer be provided to us. Over the page, please. 26.3. We found that types of document previously provided to us without restriction were no longer being provided. Some of these documents were also not being provided to Post Office's in-house team of investigators. We can only conclude that this represented a policy decision by Post Office at a senior level, possibly based on legal advice. We consider this regrettable, particularly in the light of assurances previously provided to ourselves, MPs, and the JFSA. In the light of those damning remarks, the Part 2 report stated that the limitation in the scope had significantly restricted Second Sight's ability to complete its investigation. There were other significant disputes between the Post Office and Second Sight as to the remit of their investigation, including first, Second Sight's concerns regarding the contract between the Post Office and sub-postmasters, which they considered placed sub-postmasters in a difficult position, forcing them to make good losses with inadequate information. Secondly, the transfer of risk between Post Office and sub-postmasters with changes to business processes, such as the introduction of new products and services, adding to the risks. And thirdly, a lack of improvement in what was called the, quote, error repellency of Post Office's business systems, which meant that measures to address errors with Horizon, which could have avoided and mitigated problems, were not being introduced. Despite acknowledging the limitations of its investigations, which resulted from this difference of opinion as to remit and scope, Second Sight nevertheless identified a number of what they called commonly raised issues. These included commonly raised issues, for example, with ATMs, foreign currency transactions, and national lottery sinking. Second Sight also identified issues with training sub-postmasters in respect of how to deal with discrepancies. They identified issues with the helpline, noting that a frequently recurring response by the helpline was, in response to shortfalls, quote, "Don't worry about it, it will all sort itself out," and found that in many instances, the biggest shortages seem to have arisen as a result of, quote, errors made whilst trying to correct earlier errors, end quote. The report was critical of the audit trail available to sub-postmasters, the conduct of Post Office investigators, and the conduct of prosecutions. It's perhaps not a coincidence that many of these themes were also repeated in evidence that you heard during the human impact hearings when you heard from sub-postmasters who made very similar complaints. As your inquiry proceeds to these later phases, you will have to consider whether these issues were taken seriously by the Post Office at the time. One significant issue that was raised by Second Sight that I've already touched on was that applicants reported that Horizon transactions appeared to have been entered or stock balances changed when the branch was closed and no one had access to any of the Horizon terminals. Second Sight noted that the Post Office had stated that was not and had never been possible. It had not been and had never been possible for anyone to access branch data and to amend live transactional cash or stock data without the knowledge of sub-postmasters or their staff. As I've mentioned, one applicant had given evidence relating to a facility at the Bracknell office of Fujitsu, where he was alleged that it was demonstrated to him that it was possible to alter Horizon transaction details without the knowledge of sub-postmasters. The Post Office was said to have denied that it's possible to, quote, amend branch data remotely. Second Sight identifies several apparent inconsistencies in this account, but noted the restrictions in their ability to investigate it further. They concluded that, quote, their current evidence-based opinion is that Fujitsu / Post Office did have and may still have the ability to directly alter branch records without the knowledge of the relevant sub-postmaster. That's the same reference at page 6. So it is that in April 2015, where Second Sight identified remote access as a significant issue. I've already referred to evidence that in 2010, certain Post Office employees were aware that Fujitsu had remote access, and we know from contemporaneous emails that there was a great deal of discussion about this at a senior level in the Post Office in early 2015. Cross-reference to that is poll 000-24091. However, remote access was a matter that appears to have been denied by the Post Office right up until partway through the group litigation. The inquiry will ask how it was that it took so long to admit it. A section of the report addressing, quote, error and fraud repellency and Horizon's fitness for purpose was also highly critical of the Post Office. The authors said that in not fully investigating errors made at the counter, even where it was obvious that some of those errors have been systematically repeated in a branch or even across a network, the Post Office, quote, seems not to have taken ownership of finding ways to reduce or manage those errors. On fitness for purpose, Second Sight's report identifies two different approaches. I wonder whether we could draw up the conclusions at the previous reference, poll 000-29849, this time at page 43. And it's paragraph 21.21. So you need to go down a little bit, thank you. Is Horizon fit for purpose? Quote, in trying to answer this question, we recognise that in the vast majority of cases, Post Offices sub-postmasters operate their branches year after year with minimal reported problems. For them, Horizon appears, subject to our observation in paragraph 4.6 above, to be, quote, fit for purpose. References here to the Horizon system are mainly focused on Horizon Online, which evolved from the original Horizon application and was developed in 2010. Our comments encompass not only the system itself, but also supporting processes and procedures. However, some comments received relate to earlier versions of the system, a number of enhancements having been made following user experience and feedback. For the system to be considered fully fit for purpose for all users, it would, in our opinion, need to accurately record and process, with a high degree of error repellency, the full range of products and services offered by the Post Office, whilst providing a clear transactional audit trail, allowing easy investigation of any problems and errors that arise. The cases that we have reviewed demonstrate that this design objective has not always been achieved. Then if we can go forward to paragraph 21.27, please. Thank you. Where such a person who was either unsuitable, inexperienced, or inadequately trained, they're talking about some postmasters there, was faced with problems, perhaps associated with hardware or telecommunications failures, and the system's resultant restart and recovery procedures, it was at that moment that an otherwise repairable situation had often turned into a catastrophe. For them, and in those specific and limited circumstances, Horizon could not be described as fit for purpose. As to whether there were systemic issues, Second Sight later said, quote, "When looking at the totality of the Horizon experience, we remain concerned that in some circumstances, Horizon can be systemically flawed from a user's perspective, and Post Office has not necessarily provided an appropriate level of support." Whether or not the Second Sight report can be described as finding systemic issues is a matter of significant debate. I've already highlighted the comments of the Post Office and the NFSP to the media and to Parliament prior to the publication of the Second Sight report. On the 29th of June 2015, the Parliamentary Under-Secretary of State for Business, Innovation and Skills, George Freeman, said during a parliamentary debate, Second Sight produced two independent reports, one in 2013 and the other earlier this year, both of which found that there was no evidence of systemic flaws in the system. That is an important point that I would like to reiterate in response to the opposition minister's point. Colon, there is no evidence of systemic flaws in the system. That's poll 000-304-75 at page 6. The role of government, and in particular what is now the Department for Business, Energy and Industrial Strategy, in responding to the emerging scandal, will therefore form a significant part of your inquiry. Your inquiry will also look into the breakdown in cooperation between the Post Office, Second Sight and others. It will investigate the levels of knowledge of such issues, such as remote access and systemic problems, and will identify any failures in this regard. After the break, sir, could I turn to the role of external lawyers and legal advice, again broadly chronologically, starting with advice from Mr. Altman, King's Counsel, in 2013 and 2014.
Of course. And what time should we be starting up again?
Using earlier as a precedent, 3:15.
All right, fine.
Good afternoon, sir. Can you see and hear me?
Yes, I can.
And likewise, thank you very much, sir. I was turning to advice from Brian Altman, King's Counsel, in 2013 and 2014. Mr. Altman had advised the Post Office over a considerable period of time, including representing the Post Office in the Court of Appeal in criminal appeals. He was formerly the most senior prosecution barrister in England, known as the first senior Treasury Counsel. For the purposes of the opening, I will begin on the 2nd of August 2013. That's after the Helen Rose report, the interim report of Second Sight, and the Clark advice. And on the 2nd of August 2013, Mr. Altman provided advice on Cartwright King's current processes in a document entitled Interim Review of Cartwright King's Current Processes. That's no need to display it, but it's poll 406801. He advised that the approach that was being taken by Cartwright King and counsel appeared to be, quote, fundamentally sound, but suggested that the Post Office may wish to consider the geographical limit of the review, which was limited to Cartwright King cases and English Cartwright King cases, and the temporal limit that had been applied. This had been limited to a period of only 3 years. He also advised that they should consider the extent to which non-disclosure by Gareth Jenkins was the only issue potentially forming any grounds of appeal, or whether the review should be broader. Mr. Altman raised the issue of a possible conflict with Cartwright King, essentially marking their own homework. But Mr. Altman's advice in this respect was, quote, "There is benefit in Cartwright King and its internal counsel identifying and engaging in the review of impacted cases, as they are familiar with their case files and intimate with the process." He went on to say, "But it seems to me it will be wise for me to dip sample some of their work in due course, and I may have to devise some criteria of my own for those cases I feel I should review personally." He gave some other practical advice to Cartwright King in respect of the review that they were conducting. It may become relevant that as part of the advice that Mr. Altman considered 2 copy prosecution files, something that does not appear later to have been reflected in a submission to the Court of Appeal in Hamilton, namely that this advice considered a review of the process, though not the individual decisions in reviewed cases. Now, Mr. Altman's advice during this period was not confined to matters relating to the criminal appeals, and instead it touched on other matters, including the mediation. I wonder whether we could look at poll 406769. This is a note of a consultation with Mr. Altman on the 9th of September 2013. And I just want to look at one part of it. It's on page 3 of the document. And it's the 4th paragraph from the top, starting BA advised, and BA meaning Mr. Altman. So the 4th paragraph in, Mr. Altman advised considerable caution in relation to mediation cases involving previously convicted individuals. Brackets, Seema Misra has already indicated an intention to be within the scheme. The concern is that lawyers acting for those individuals may be using the scheme to obtain information which they would not normally be entitled to in order to pursue an appeal. The inquiry will be looking at how the advice that was being given in relation to the approach to mediation and the subsequent group litigation influenced or was influenced by advice that was given in relation to the criminal appeals. We know that Seema Misra's appeal was quashed on the grounds that her prosecution was both unfair and an affront to justice. But that didn't occur until the 23rd of April 2021, some 8 years later. The Court of Appeal identified significant failings in her prosecution, including a failure to grant a defence request for Horizon data and wrongly placing of an article relating to the integrity of the system in a schedule of sensitive material. A question that will be asked is that should she and others in a similar position have been provided with more information and earlier? And if so, why wasn't she? And what role did legal advice of this kind provide about exercising considerable caution in relation to mediation cases? On the 15th of October 2013, Mr. Altman provided his, quote, general review. That's poll 406803. He again advised that the Cartwright-King review was fundamentally sound and that he had not detected any systemic or fundamental flaws in the review process or the evidence arising from it, albeit that that should be kept under review. One important aspect of this advice concerned the role of Gareth Jenkins, with Mr. Altman agreeing that Mr. Jenkins was, quote, tainted, and his position as an expert witness is untenable, end quote. We know from the Horizon Issues judgment that Gareth Jenkins contributed to the evidence that was relied on in the group litigation, albeit the Post Office chose not to call him as a witness and thereby subject him to cross-examination. The inquiry will ask whether it was appropriate, in the light of the advice received from both Mr. Clark and to Mr. Altman, to behave in this way, to approach the litigation in this way. By late 2013, Mr. Altman was also advising the Post Office on their investigative and prosecutorial roles. On the 19th of December, he provided written advice entitled Review of Post Office Limited Prosecution Role. That's Poll 406802. An earlier draft of this advice had been circulated by him and commented on. In the advice, Mr. Altman concluded that he had seen no evidence to suggest that Post Office exercised its investigations and prosecutions functions in anything other than a well-organised, structured and efficient manner, through an expert and dedicated team of in-house investigators and lawyers, supported by Cartwright King solicitors and their in-house counsel, as well as external counsel and agents when required. He concluded that there was no good reason to recommend that the Post Office should discontinue its prosecution role. He did, however, make some recommendations for improvements. This advice contained at the end of it, and we'll see this when we come to examine it, a brief CV of its author, Mr. Altman, by way of footnote, and recorded that he had been First Treasury Counsel and was, amongst other things, a recorder of the Crown Court and a bencher of Middle Temple. The inquiry will consider what role advice of this kind, presented in this way, had in the Post Office's subsequent conduct, and whether advice of this kind provided the Post Office and its leadership with a comfort blanket. Moving to 2015, on the 8th of March 2015, Mr. Altman gave important advice to the Post Office concerning the charging of theft and false accounting. That's Poll 406588. This was during the course of the investigation by Second Sight, just before their contract was terminated or ended. And the premise of the advice was that, quote, Second Sight were beginning to advance arguments that the Post Office is abusing its prosecutorial role by charging sub-postmasters with theft when there's no evidence of it, in order only to pressure sub-postmasters into pleading guilty to false accounting. Cartwright King had advised that the suggestion that the offence of false accounting was a less serious offence to that of theft, was incorrect, because they were both offences of dishonesty and both carried the same maximum sentence. That position was communicated to Second Sight, see Poll 30400868 as follows, quote, the suggestion that the offence of false accounting is a less serious offence to that of theft is incorrect. Both offences are equal in law. Both are offences of dishonesty, and both carry the same maximum sentence. The advice noted that Sir Anthony Hooper, meanwhile, had said that false accounting was a lesser charge than theft, and that Second Sight were not incorrect to characterise it as such. The advice from Mr. Altman was sought to ensure that the statement made to Second Sight to the contrary by the Post Office was, quote, defensible. Mr. Altman's view is set out at Poll 406588 at page 5. And he says, quote, if I may say so, the so-called equality of the offences is an unnecessary and unprofitable focal point of attention. The other issues raised by the letter have greater force and are defensible. His conclusions at page 7 were as follows. First, both offences of theft and false accounting do involve dishonesty and do carry a maximum sentence of 7 years imprisonment. The only argument that may be advanced to defend the statement is that it is accurate, quote, within the narrow context within which it was stated. Third, the point was that false accounting may be a lesser offence and may often be a lesser offence in the context in which it is charged. So to argue it is not a lesser offence is not accurate. It all depends on the individual circumstances of the case. Fourth, the statement was undermined by the fact that the seriousness or otherwise of any offence of theft or false accounting must always depend on its own facts, as is demonstrated by the many ways in which such offences may be committed and how offenders may be sentenced for them. What does not appear is a blunt and unequivocal statement to the effect that where both theft and false accounting are charged for the same conduct, the charge of false accounting may be seen as less serious, which appears to be exactly the point that Second Sight and Sir Anthony Hooper were both identifying. Also not addressed is whether in practice an innocent person may be more likely to plead to what may be perceived as a less serious charge, and whether barristers and solicitors are likely to advise their clients that false accounting is in practice less likely to result in a prison sentence. Another significant strand of legal advice was provided in the form of a review conducted on behalf of the then chairman of the Post Office, by this time, Tim Parker, on the 8th of February 2016. The reference is Poll 406355. It was carried out by Jonathan Swift, then Queen's Counsel, now High Court Judge, and former First Treasury Counsel, together with a junior, Christopher Knight. I'm going to call this document the Swift Review. The purpose of the Swift Review was said to be to consider whether any further action could reasonably be taken by the Post Office to address the complaints by sub-postmasters about their treatment. The review concentrated on 4 areas. First, criminal prosecutions. Second, the Horizon system. Third, the support provided to sub-postmasters through training and helplines. Fourth, the investigations into the circumstances of specific complaints where a complaint had been made. First, criminal prosecutions. In respect of the safety of convictions and the disclosure of information, the Swift Review noted that none of the Second Sight's reports identified systemic flaws in the Horizon system likely to have caused the losses incurred at the relevant branches. Rather, it was said that operator errors at the counter was the usual cause identified by Second Sight, with the likelihood of those errors being exacerbated by problems in training and support. From this, the authors of the Swift report understood, quote, "There is no evidence that the Horizon system is responsible for the losses which have resulted in convictions." That's paragraph 95. The Swift Review observed that a considerable exercise had been undertaken by Cartwright King in 2013 that was the subject of advice and oversight by Mr. Altman. Mr. Altman had considered both the process adopted by Cartwright King and their actual decisions in a sample of cases to be reasonable and proportionate. The Swift Review also reviewed a small sample of reviews that had been conducted by Cartwright King. The conclusion of the Swift Review in this respect, same reference, page 33, is we are accordingly content that Poll has acted reasonably in its handling of disclosure issues arising in relation to past criminal prosecutions. Following this conclusion, the Swift Review stated that it would be inappropriate for the Post Office to conduct a wider review of the safety of any particular conviction when that work was being carried out by the CCRC. That conclusion that the Post Office had acted reasonably in its handling of disclosure issues is a conclusion of some significance, and we will investigate the basis of the conclusion. Was the Swift Review given sufficient disclosure by the Post Office, for example, in this regard? Was there information that the Swift Review was not provided with, which might have altered the conclusion? Was too much reliance placed on the previous advices of Mr. Altman in the Second Sight Review? In respect of the sufficiency of evidence, the Swift Review noted the allegation that the Post Office had too readily brought a charge of theft with the aim or effect that a sub-postmaster is pressurised into pleading guilty to false accounting in the hope that the theft charge is dropped, and because a theft charge would more readily enable the Post Office to recover its losses. They noted one case in which there was a guilty plea to false accounting, in return for which a theft charge was not pursued, where certain documents in the prosecution file indicated that initial post office investigators could not find any evidence of theft, despite it being charged. In this regard, the Swift Review relied on Mr. Altman's advice of the 8th of March 2015 that I've already mentioned, where he had said that it was not a helpful question as to whether theft and false accounting were offences of equal seriousness. It also noted, for example, that the decision to plead guilty was a matter for the defendant alone, that the Post Office's position was that its prosecutorial decisions were always taken in accordance with the Code for Crown Prosecution Service, the Code for Crown Prosecutors, and that Cartwright King must have considered the evidence. The Swift Review noted the Post Office's position that because of these points, and because any review would be carried out with the benefit of hindsight, it would not be an appropriate course of action now to review prosecution files to reconsider the sufficiency of evidence issue. The authors of the Swift Review strongly disagreed. They stated, page 35, same reference, quote, "We do not agree. We've reached the view that this issue is one of real importance to the reputation of Pol and is something which can feasibly and reasonably be addressed now. It's clear that it's not an exercise which has been carried out so far, and Cartwright King were not asked to consider the sufficiency of evidence when undertaking their disclosure review. We do not think it is safe to infer that any advice Cartwright King gave on Pol's position on any appeal must have involved a full evidential review. The allegation that Pol has effectively bullied sub-postmasters into pleading guilty to offences by unjustifiably overloading the charge sheet is a stain on the character of the business. Moreover, it is not impossible that a sub-postmaster will have felt pressurised into pleading guilty to false accounting, believing it to be less serious when they might not otherwise have done so. The phenomenon of false confessions is well known. Your inquiry will investigate how widely this part of the advice, in which strong advice was given, was shared, and if not, why not? It has been reported that the advice was not shown to the board of the Post Office, despite such trenchant criticism being made in the passage that I've just cited. We'll investigate that those reports of how widely the advice was shared are correct, and if they are correct, why the advice was not shown to the board. The Swift Review then looked at criticism that had been levelled at the Post Office concerning its ability to conduct private prosecutions in the absence of specialist criminal expertise that the police has or the independent view that's applied by the CPS. This was dealt with briefly in the advice, which noted that Mr. Altman had provided advice in this regard on the 31st of October 2013, and that a revised prosecution policy was waiting approval. The review made two recommendations in respect of criminal prosecutions. Firstly, that advice be sought from counsel as to whether the decision to charge a sub-postmaster with theft and false accounting could undermine the safety of any conviction for false accounting, where the conviction was on the basis of a guilty plea, following which and or in return for which the charge of theft was dropped, and where there had not been a sufficient evidential basis to bring the theft charge. Secondly, if such a conviction could be undermined in those circumstances, that counsel review the prosecution file in such cases to establish whether, applying the facts and law applicable at the relevant time, there was a sufficient evidential basis to conclude that a conviction for theft was a realistic prospect such that the charge was properly brought. The Swift Review accepted, when it considered the Horizon system, on the basis of what the authors had seemingly been told, that the Horizon system works, quote, effectively and accurately for the overwhelming majority of the time, and for the overwhelming majority of its users is accurate, it's paragraph 119, and saw no basis to recommend further action be taken on the bugs that had been identified. However, the review raised concerns that the analysis that had so far taken place was, quote, bottom-up, in the sense that it started from and focused on the specific circumstances of the branch, rather than a top-down approach of searching for patterns of unusual behaviour in individual branches and across branches on a purely data-driven analytical basis, which might suggest a wider problem. The review then looked at the consistent assurances from the Post Office and Fujitsu that transaction records, and therefore branch balances, could not be remotely altered without the knowledge of a sub-postmaster. The SWIFT review considered a range of evidence, including the second sight reports and the reports produced by Deloitte in May and June 2014, and it concluded as follows. This is poll 406355. At page 51. Quote, "It seems to us that the Deloitte documents in particular pose real issues for Poll. First, both the existence of the balancing transaction capability and the wider ability of Fujitsu to, quote, fake digital signatures are contrary to the public assurances provided by Fujitsu and Poll about the functionality of the Horizon system. In the light of the consistent impression given that they do not exist at all, we consider that it is now incumbent upon Poll to commission work to confirm the position insofar as possible. Second, the Deloitte reports, or at least the information contained with them, may be disclosable under Poll's ongoing duties as a criminal prosecutor. As I've already observed, remote access was a matter that appears to have been denied by the Post Office until 2019, until partway through the group litigation. Yet it was raised as a significant issue once again in this review in February 2016. The chairman, Tim Parker, on behalf of whose review this took place, chaired the Post Office throughout the group litigation. The inquiry will investigate what, if any, action was taken by him at this time. In the light of these findings, the SWIFT review recommended, first, that the Post Office consider instructing a suitably qualified party to carry out an analysis of the relevant transaction logs for branches within the scheme to confirm, insofar as is possible, whether any bugs in the Horizon system are revealed by the data set which cause discrepancies in the accounting position of any of those branches. That the Post Office secondly consider instructing a suitably qualified party to carry out a full review of the use of balancing transactions throughout the lifetime of the Horizon system, insofar as possible, independently to confirm from the Horizon system records the number and circumstances of their use. Third, that the Post Office instruct a suitably qualified party to carry out a full review of the controls over and use of the capability of authorised Fujitsu personnel to create, amend or delete baskets within the sealed audit store throughout the lifetime of the Horizon system, insofar as possible. Fourth, that the Post Office sought specialist legal advice from external counsel as to whether the Deloitte reports or the information with them concerning balancing transactions and Fujitsu's ability to delete and amend data should be disclosed to the defendants of criminal prosecutions brought by Post Office. This advice should also address whether disclosure should be made, if it hadn't been made, to the CCRC. The inquiry will seek to establish what action was taken as a result of that advice. In terms of the support provided to sub-postmasters, the SWIFT review noted that complaints have been made regarding the training that sub-postmasters have received and allegations that the support provided through the MBSC was unhelpful and misleading. This was not a significant part of the review, it seems, because the authors acknowledged several limitations in the ability definitively to deal with each individual allegation. However, during the course of the investigation, it had emerged that calls to the NBSC were recorded against the identity of the call handler, and it was therefore possible for the Post Office to cross-reference complaints against the personnel files of call handlers. They recommended as following. First, that Poll cross-reference specific complaints about misleading advice from NBSC call handlers with the possible employees who provided that advice and consider their personnel files where available for evidence as to the likelihood that the complaint may be well-founded. The authors did not make recommendations with regard to training and support on the basis that rather than looking at past cases, this was an area that the greatest amount of work could be done to improve the situation in future, and that the Post Office had already accepted the need to do that work across all areas of the business and in detail. In the final section of the SWIFT review concerning the independent mediation scheme, that part of the review proceeded on the basis that the Post Office was entitled to treat only those who had applied to the scheme as raising serious or material complaints about Horizon and the Post Office's treatment of them. The review considered the processes involved in the scheme and considered in detail a 10% sample from those cases where there had not been a conviction. That limited sample was only 11 cases in total. The SWIFT review was seemingly impressed by the work that had been carried out by the Post Office. In some respects, the review was critical of the lack of assistance by sub-postmasters in highlighting potential causes or time periods or errors in the information that they had given. The review stated that it was extremely difficult for any third party or the sub-postmaster after the passage of time to review the records to identify precisely what went wrong. They expressed surprise at how many of these cases, to use the words of the authors, blatant instances of false accounting, rendering Pol's task of assisting the sub-postmaster in working out where problems had arisen very much harder without an accurate reference point from which to work. The SWIFT review made only one recommendation in respect of the scheme. This concerned an issue which had been raised by Second Sight in relation to the handling by the Post Office of unmatched credit balances in its own suspense account in respect of third-party clients, such as Santander or Bank of Ireland. Second Sight had identified that where there were significant sums in unmatched balances, it was possible that at least some of the money would reflect uncorrected transaction discrepancies in particular branches. The SWIFT review found this was worthy of investigation and recommended that Pol commission forensic accountants to review the unmatched balances on Pol's general suspense account to explain the relationship or that lack thereof with branch discrepancies and the extent to which those balances can be attributed to and repaid to specific branches. The inquiry will be considering what information was provided to the SWIFT review, and in particular, whether the authors were aware of all of the information which raised reliability issues, which I have mentioned over the course of the past day and a half. If they were not provided with this information, was that intentional? And who made the decision not to provide them with it? Why did the authors meet, amongst others, Gareth Jenkins, and what did they know of the concerns that had been raised concerning his credibility? Importantly, the SWIFT review was identified by Paul Scully, the relevant minister in 2020, as having concluded that, quote, there were no systemic problems with the Horizon system. The inquiry will look into the extent to which that often repeated phrase was actually an accurate reflection of the SWIFT review. You will hear about who saw the full report and when, and where it wasn't shared, why it wasn't shared. Further advice from Mr. Altman. He was asked to advise the Post Office following the SWIFT review, and this advice was dated the 26th of July 2016, entitled Review of Post Office Limited Criminal Prosecutions. It's to be found at Poll 406394. He reviewed 8 individual cases that were apparently selected because they were high-profile cases within the group litigation or CCRC cases. Mr. Altman concluded that those cases that fell squarely within the remit of his review were conducted in such a way that the allegation that Post Office had operated a deliberate policy to charge theft when there was no or no sufficient evidence to support it, just to encourage or influence pleas of guilty to charges of false accounting is, quote, fundamentally misplaced. He stated, not only is there no evidence of such a policy, there is positive evidence that each case was approached both by internal and external lawyers professionally and with propriety, and unquestionably case-specifically. He went on, quote, not only have I found absolutely no evidence of the existence of any such policy, I've also not discovered any evidence in the cases that I have been invited to review that theft, or fraud for that matter, was charged without any proper basis to do so, and or in order only to encourage or influence guilty pleas to offences of false accounting. Mr. Altman also touched on the issue of whether it was inappropriate to use the criminal justice system as a means of enforcing repayment from offenders by charging and pursuing offences that will result in confiscation and compensation orders. His view was that based on the Code for Crown prosecutors, it was appropriate to consider, amongst other things, when selecting charges, the court's sentencing powers and the imposition of appropriate post-conviction orders, and that in the cases he reviewed, these considerations were properly made. The inquiry will investigate how this advice fits with public comments that have been made by Sir Anthony Hooper, who was directly involved in the mediation process. He's expressed views, most recently, that he pointed out to the senior management of the Post Office that there was unlikely to be theft in the cases that he had seen because of a number of factors, including, first, the previous good character of the postmasters concerned, secondly, the short-sighted nature of any theft, given that the sub-postmasters would be liable to make up any shortfalls, and thirdly, that there was nothing to suggest that they were stealing and no actual evidence of financial loss. For him, the more likely cause was that it was down to Horizon. You will investigate how that advice to the Post Office sits with other advice that was obtained, which was supportive of the Post Office's approach to theft charges. Mr. Altman also provided an advice called Advice on Settlement, which addressed the risk to the safety of convictions if Post Office entered into settlement with any of the claimants in the group litigation. The advice dated the 17th of June 2019, there's no need to turn it up, it's at poll 406401, was as follows. 1. Any admission of wrongdoing by the Post Office to convicted claimants was to be avoided, quote, as is any public apology that risks misinterpretation or the implication of an admission of fault. 2. There was, quote, a real risk of Post Office taking an approach which could be interpreted as incongruous with the processes it instituted as a prosecutor. 3. Settlement would invite critical scrutiny not only of Post Office's prosecution function, but also of its prosecutorial decision-making function during the pre-trial and trial processes. 4. Settling or seeking to settle, quote, may be viewed as a sign of weakness, a lack of confidence in both its civil and criminal cases by the convicted claimants as well as the CCRC, who may then be encouraged to investigate, quote, the technical aspects of the case heard in the Horizon Issues Trial evidence and seek to appeal or to make a reference which will potentially open the settlement agreement or the rationale underlying it to consideration or questioning by the Court of Appeal as part of any appeal/reference hearing. And fifth, there was in Mr. Altman's judgment, quote, some risk to the safety of convictions of including convicted claimants in any settlement agreement or package. As I noted in respect of the earlier advice, the inquiry will look at the role that advice of this kind from senior lawyers had on the strategy that was adopted by the Post Office towards mediation and settlement. Is it right to delay or avoid settlement because of the impact that it might have on a criminal appeal, is the question that might need to be addressed. Further advice was provided by Mr. Altman on the Common Issues Judgment and the Horizon Issues Judgment. In the latter advice, Mr. Altman advised on the impact of Mr. Justice Fraser's judgment on criminal convictions and resultant disclosure obligations. His advice was that appellants and the CCRC would have a high hurdle to overcome in respect of non-disclosure because they would have to show that it was material. At the end of his advice, Mr. Altman noted that the apparent late concession in the litigation to entries having been, quote, entered, edited, deleted, negligently or dishonestly, close quotes, remotely, was, quote, a startling concession, close quote, and requested further information in that regard. Your inquiry may investigate the extent to which those who were advising the Post Office were provided with sufficient information on which properly to advise. It wasn't just Mr. Altman or Sir Jonathan Swift who provided advice to the Post Office. There was, of course, a large legal team who represented and advised the Post Office in respect of the group litigation. And can I refer you to issues 178 to 181, sir, in the completed list of issues. Your inquiry is tasked to determine whether the litigation strategy adopted by the Post Office was appropriate. In doing so, you will wish to consider the content of legal advice provided and the extent to which the Post Office relied upon it in adopting the strategy it did to the Bates litigation. The Post Office was represented by Womble Bond Dickinson LLP, previously just called Bond Dickinson, in the group litigation. You will hear that the firm was retained to provide advice in relation to other aspects of the Post Office's response to the emerging scandal. But I focus on the GLO action in this opening. Before I turn to address the litigation strategy and outline, I must touch on why it's important to address issues beyond the Bates case itself. You will wish to consider how that litigation strategy influenced or affected the Post Office's wider response to the emerging scandal. In a letter at Poll 406601 from Womble Bond Dickinson to the Post Office, summarising advice that it had given at a conference on the 8th of June 2006, 2016, thank you. It states that Tim Parker, the chairman of the Post Office, was continuing to consider the recommendations from the Swift review, which I raised earlier. The letter says that the, quote, very strong advice was for Mr. Parker's review to cease, with some of the recommendations being implemented by the legal team to seek to preserve privilege. Therefore, the inquiry will investigate both the effect of the litigation strategy on the Bates claimants themselves, but also on the wider impact that it had on the Post Office's response to the emerging scandal as a whole. In particular, you may wish to consider whether the strategy in the Bates litigation resulted in delays to the overturning of convictions or delays to changes in practice in respect of Horizon. I've already set out the background to the substantive judgments by Mr. Justice Fraser upon which this inquiry builds. He was critical of the Post Office's approach to the litigation. You will in due course be referred to a significant amount of expert and legal advice, much of which was previously privileged, that fed into the Post Office's decision-making. In particular, you'll be referred to the input that Fujitsu had into preparing for the Horizon Issues trial. And again, Gareth Jenkins emerges as a key player in this regard. You will also read the advice that the Post Office received from legal professionals. You'll read that Womble Bond Dickinson provided advice to the Post Office on the potential for a group action in 2014 and then acted in the claims that arose, and that various leading counsel, Queen's Counsel as they then were, and junior barristers acted for the Post Office in this action. As you would expect for such significant litigation, the legal professionals provided advice regularly and on a great range of matters. You will read evidence of advice provided to Post Office in steering group meetings, as well as in formal notes and conferences. This advice ranges from the merits of specific points of law to how to approach key events in the litigation, such as disclosure. By way of example, Womble Bond Dickinson advised the Post Office on the merits of pursuing counterclaims in the GLO, recommending pursuing claims in debt for shortfalls, but not damages for loss of profits arising from termination. That's Poll 406618. You will wish to consider the content of the advice received, the extent to which the Post Office relied on it, and whether it was reasonable to do so. Accordingly, it will be necessary to consider broadly the merits of such advice. We do not suggest that you subject it to detailed analysis and approve or criticise it because you either agree with it or disagree with it. The question must, of course, be much broader and ask whether the advice on which the litigation strategy was founded was within the range of what a reasonable practitioner might consider to be appropriate. Moreover, you'll wish to consider whether those legal professionals were being given sufficient information to advise the Post Office and Fujitsu. One further point that I should address is the recusal application that was made in the group litigation. As you're aware, an application for recusal is a serious matter where a party asks a judge to step down from hearing a claim, usually because of alleged actual or apparent bias. It's clear that the Post Office's legal team advised on concerns over Mr. Justice Fraser's handling of the litigation prior to knowing the result of the Common Issues trial. You'll see an update note to Post Office following a case management conference in the Horizon Issues trial, which refers to the fact that the judge did not censure the claimants for a last-minute change of position, stating this, quote, reinforced a growing concern that the judge is not willing to call out bad conduct by the claimant's lawyers, even when it is blatant. We can only speculate why he acts in this way, but believe this stems from a fear of negative media comments and or an acknowledgement that the claimants do not have the best representation, and so he is attempting to level the playing field. Following the draft judgment in Common Issues, the Post Office's legal team gave initial advice that, quote, the judge's approach is astonishing. It is unfair and unprecedented. With no hesitation, we strongly recommend lodging an appeal. That's Poll 000-22940. Leading counsel subsequently advised on the prospects of success of an appeal, Poll 000-23878, and also recommended that the Post Office consider making an application to seek the recusal of Mr. Justice Fraser on the grounds of apparent bias. You will be aware that the test for apparent bias is whether a fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility that the judge was biased. If the answer is yes, the judge must cease sitting on the claim, irrespective of whether he was in fact biased. This advice on recusal was given the day before the Horizon Issues trial was due to start. The issuing of a recusal application was described, quote, as the nuclear option. It was clear that it would cause delay to the Horizon Issues trial, even if unsuccessful. The Post Office sought further advice on this issue from a former President of the Supreme Court, Lord Neuberger, and head of his chambers, Lord Grabiner, in respect of the application for Mr. Justice Fraser to recuse himself. On the 14th of March 2019, Lord Neuberger provided an 8-page written advice entitled Bates and Others against Post Office Limited, Observations on Recusal Application. That's at Poll 406398. Lord Neuberger advised that there were reasonable grounds for the Post Office to bring an application to recuse the judge, and that the Post Office, quote, has little option but to seek to get the judge to recuse himself at this stage. Lord Neuberger is subsequently noted to have attended a Post Office board meeting and provided advice. That's Poll 000-21562. It was noted that Lord Neuberger could not represent the Post Office because he was formerly a member of the judiciary. Shortly afterwards, Lord Grabiner is noted to have given strong advice in conference that the Post Office should pursue the recusal application. That's Poll 406397. No need to display the document at the moment. Within the conference note, it says as follows in relation to what Lord Grabiner is said to have advised. Quote, Lord Grabiner explained that in his view, if there is no recusal application made, then the Post Office will lose the series of trials set up in this matter. Without a recusal application, Post Office is stuck with this judge. An appeal on the law may correct some of the very significant errors in the Common Issues judgment, but then the case will be sent back to this judge, who has demonstrable apparent bias against Post Office, and hence the firm conclusion that Post Office will lose, and the financial impact of that will be substantial. Recusal is therefore essential, and Lord Grabiner asserted that in the face of legal advice from Lord Neuberger that recusal should be applied for, and the quantum of damages that Post Office will pay out on a loss, then it was Lord Grabner's view that there was a duty on Post Office to seek recusal. Lord Grabner stated that in his view, the board of the Post Office had no option but to seek a recusal. The note of the conference recorded Lord Grabner as advising that there were strong arguments in favour of recusal. It was his strong view that a recusal application was the right course of action, that there was a serious prospect of success, and, quote, that this judge had done an unbelievable nonsense and demonstrated apparent bias. The application for recusal was made midway through the evidence in the Horizon Issues trial. As a result, the hearing had to stop whilst the Post Office's application was determined. The application caused significant delay and disruption to the Horizon Issues trial and was subsequently rejected by Mr. Justice Fraser. The Post Office sought to appeal that decision. You will be aware that the Post Office needed to obtain permission to appeal by showing that there was a real prospect of success or some other compelling reason to hear the appeal. But Lord Justice Coulson refused the application for permission to appeal and delivered an unusually lengthy set of reasons for doing so. Those reasons were highly critical of the Post Office and stated, quote, that the recusal application never had any substance. Once again, the role of lawyers, some of them senior, the sufficiency of the information that they were given and the extent to which they were relied on in forming the Post Office's litigation strategy will be examined. I've only examined one of the issues that arises in this part of the inquiry's list of issues. So that's all I wanted to say about phases 4 to 6. Finally, and most likely around this time next year, the inquiry will address current practices and procedures and recommendations for the future. By examining in phase 7 current practice, you will be able to consider whether the Post Office, Fujitsu, the Department for Business, Energy and Industrial Strategy, and any other relevant organisations and individuals have learned from these experiences, or, on the other hand, whether any further changes need to be made by way of recommendations by you. So that's all I intended to say. Well, I say all, it was quite a lot. That's all I wish to say in opening the upcoming phases of the inquiry to you, sir. I've said to other court participants that it was unlikely that I would finish before 4:10, and therefore it was unlikely that you would call on them today, and therefore the sub-postmaster court participants have arranged for their clients to start viewing tomorrow morning. I trust that wasn't out of order.
Not at all, Mr. Beer. I'm very grateful for your opening, and I look forward to hearing the remainder of the openings. Can I take it that you are all, and I'm addressing Mr. Beer, but I'm talking to all the co-participants who wish to make an opening. Are you still reasonably confident that we will complete all the openings by a reasonable time on Friday?
So yes, we are, because Mr. Maloney, Mr. Steen and Mr. Henry have told me that their estimates have reduced somewhat from those that were originally given. And in any event, we had, if you remember, the spare afternoon on Friday afternoon.
Yeah, I raised it in particular because in our provisional timetable, only 30 minutes was set aside for UKGI, but in writing at least, there's quite a long opening to be made by that party. So I just wanted to be clear that it could all be accommodated this week.
So yes, I don't think they've actually notified an expanded time estimate. Mr. Mertens is just getting to his feet.
Yes, thank you very much. We don't expect to be more than 30 minutes.
Fantastic, thank you very much. Just one piece of housekeeping.
Sorry, I missed that, Mr. Beer. The screen didn't move quickly enough.
So I can repeat what Mr. Mertens said. He got
Yeah.
to his feet and said they are not going to be more than 30 minutes, UKGI.
Fine, right. Well, that solves the problem. Fine.
It does. Just one piece of housekeeping. Can I repeat, by way of parish notices to people, the need to ensure that they lodge with the inquiry at the council at email address any questions that they wish us to ask or they wish to ask of any witnesses in this phase of the inquiry 14 days before that witness gives evidence. We haven't received many questions sets so far. Quite a few were received today, but they're obviously a little late. We could, on one view, think that that means nobody wants any questions asked, or that they don't want to ask any questions themselves. We don't think that's the case. Can I therefore reiterate a plea that was sent out in an email last night from the solicitors to the inquiry, that such pro formas are received by 4 p.m. 14 days in advance of the day on which the witness gives evidence. It's not particularly for my benefit or the counsel team's benefit, so we can spend longer thinking up our questions. It's so that the inquiry can notify witnesses of the documents to which they may be referred, and in many cases provide them with the documents in hard copy. A number of the people concerned are of an older generation, do not have access to information technology that allows them to view documents online. We therefore have to print all of the documents to which they might be referred, bundle them up in a convenient way, and courier them to them. Any days that are missing under 14 days interferes with that process very significantly.
Well, clearly, Mr. Beer, I want to endorse what you just said. And I think I should note that perhaps unusually in a modern inquiry, I'm prepared to countenance persons other than you and your team asking questions. And I thought that to be appropriate in this particular inquiry. But for that to work, we need to stick rather rigidly to the timescales that you're talking about. Otherwise, I fear we will get into all kinds of logistical problems. So I endorse entirely what Mr. Beer has said.
Thank you very much, sir. So 10 o'clock tomorrow, please.
Yes. Yeah.
Thank you.
See you all tomorrow at 10 o'clock.